And welcome back. Will Worsham joins us now for this week's Speaking Legal Discussion. Good to see you.
Good to be here.
You came through the storms that we had just the other night like smelling like a rose.
Yeah, we did really, really well.
What? Because something did happen on your property.
Yeah, well, we had a tree. It's real close to one of our outbuildings, and it had been looking for some period of time like it was going to fall.
Yeah.
And when it did, it was going to fall on this building because of the way it was leaning. So I knew we were going to have to take it out, but the tornado did it for us, blew it down, and pushed it to the east instead of to the north, and so it missed the building and everything.
So it fell where you would have dropped it.
It fell exactly where we would want it to go.
Yeah.
So, yeah.
That's rare that would happen,
But our neighbors got hit pretty good. Several barns all around us are down and destroyed. So
The capricious nature of storms.
it really is.
Yeah.
Yeah, all right. Now, today we're going to shift gears because this is why you're here. Of course.
Yeah.
It's not just a fun story, but we're going to focus more on estate planning for blended families.
Sure.
We've talked a little bit about that, but I know there's more.
Well, yeah, and then we can talk about this for a long time, but there's really two different places where you have to think about this. One, you may be in a blended family yourself. Mm-hmm. Your spouse has previous kids from a previous marriage, or you do, or you both do, and maybe you have some together. But then maybe you're also thinking about planning for what if our children are in a blended marriage or might end up in a blended marriage. And so sometimes we do planning so that instead of doing an outright bequest to the beneficiaries, we hold that in trust for the benefit of that beneficiary, but then do an outright distribution fully to their children or their grandchildren. So just in case if there happened to be a death and a remarriage situation, that you're protecting those assets for your bloodline.
So you got to look a little more into the future.
If you want to do something like that, now maybe you don't have that type of concern. Maybe you know your daughter-in-law, son-in-law well enough that you're not worried about that. You know they're going to take care of all of those kids, and it's going to be taken care of okay. But if you want to build in some additional protection for sure to make sure that all of the assets stay with your bloodline, you can certainly do that.
So in other words, rather than putting a name of a child on it, you would maybe put the name of a grandchild?
Well, what you'll do
specifically?
Ultimately, yes, but what you would do is instead of distributing the assets upon your death just by writing a check, giving them the money, what's called outright, the trust remains in effect, it becomes irrevocable at that point because you've passed away, you're the only ones that could change it, and then there's a new trustee that can spend that money for really anything that your child requests it for, health, education, maintenance, support, and it can be interpreted rather broadly, but title never passes to them directly. So if they were to get divorced, that asset is still retained by the trust, and a divorcing spouse can't get to that inheritance. And then when that person, that beneficiary passed away, then you would distribute it outright to the grandchildren at that point.
Man, you really have to think that through. And when you really, I mean, there's so many more blended families, and when you start really thinking about the implications down the road, and this would be kind of a Bruce Porter question, but I think there are sometimes tax benefits to skipping a generation too. That's a whole other deal, yeah. Mm-hmm. But
and you don't necessarily have to have grandchildren that are born at that time. You can say this is where it's going to the direct.
Sure.
You can.
Normally we'll use language like my then living grandchildren and not name them specifically because they may pass away, there may be afterborn grandchildren, but that way we've created a class that we're making a bequest to it rather than individuals, because if it's individuals, then anytime those individuals change, the documents have to be changed. And we like to tamper with them as little as possible.
And this is why you find an expert to line this all out, because there seems to be pitfalls you can easily run into.
Well, it's a lot of times people don't think through all of the possibilities, things that could happen, might happen. We deal with this in business planning all the time. People have a great plan for when everything goes well, but you've got to make a plan for when maybe things don't go so well also.
Yeah, pay attention to that before it is too late. If you have a legal question for Will, email him at wworsham@colorton.com and he will answer your question right here on the show. Good to see you. Thanks so much for coming in.
And up next, we'll be right back here, but this time we'll be with our money man.
The one I just mentioned, Bruce Porter.
Yep.
So don't go away.